All right. We are on the record in 231-500-139, State of Utah versus Kouri Richins. Can I have counsel for the state make their appearances?
Good morning, Your Honor. Brad Bloodworth, Lindsay Shervanack, Margaret Olson, Joseph Hill, and Fred Burmester for the state.
Welcome to all of you. For the defense, please.
Wendy Lewis, Catherine Nestor, and Alexander Ramos, and Ms. Richins is present.
Good morning, Ms. Richins. All right, we're here for an evidentiary hearing on 3 motions to suppress. We previously had a discussion on the record regarding initial burdens. I've made notes on the motions that match that discussion. Which motion do you all want to handle first, or is there an agreed order of events?
Your Honor, there's an agreed order that roughly follows chronology. The first is the motion to suppress statements and evidence. The state, for 3 of the 4 issues raised in that motion, bears the burden, so we've agreed that the state will just go first.
Okay.
On that. The second motion is the motion to suppress electronic data. The defense bears the burden on that motion. The defense will go first on that. The third in order is the motion to suppress the letter. Again, the defense bears the burden. They will go first.
Who is the state's first witness?
Your Honor, the state's first witness is Detective Eric Maynard. But before we get there, the state would like to move into evidence what we have previously marked as exhibits 1 through 149. Move into evidence for the purpose of this hearing only.
Is there a stipulation to that effect?
Your Honor, we got these exhibits at like 10:30 last night. I was already asleep. So can we just do that at the end? I mean, whatever he ends up using. I don't expect we're going to object to any of these, but just because I haven't gone through them all, can we just they come?
It would be helpful to me to have a record of what's being offered through which witness so I can understand and have some notes. Any objection?
Your Honor, in a sense, the state is offering them into evidence now, kind of considering both the evidentiary standard for a hearing like this,
right,
under 1101 referring back to 104. The state does not intend to address most of these exhibits today. Rather than the state is moving them into evidence to use them to reference in our follow-on papers.
I appreciate that. Are you going to be laying any foundation for the ones you don't expressly reference today? For example, there are, it appears, numerous either transcripts or notes from telephone calls. Is somebody going to talk about where those came from or when they were secured?
Your Honor, we can. All the phone calls referenced are jail phone calls using HomeWave, the jail phone call system, which, I don't know, we have laid foundation for several times throughout the course of the proceedings.
Right.
I think kind of the only, to my mind, audio and video recordings that we haven't discussed in other proceedings in some fashion are a video recording by Detective Maynard, an audio recording by Detective Woody, and a video recording by Detective O'Driscoll. I will address each of those recordings in my examination of those witnesses.
I appreciate all of that. Guess it's up to the state to proceed how you want, but I'd hate to see you miss a short opportunity to lay some basic foundation for some things that you want to refer to in the briefing rather than just call a witness who can say this is how this stuff was gathered. You need to provide some foundation for reliability. It doesn't need to meet the formal admissibility threshold that would be required under a formal application of the rules of evidence. But there has to be some foundation for reliability.
Yeah, I appreciate that, and I guess to some edge we can do that. I think mostly we're talking about warrants, self-authenticating documents.
Sure.
I'll bear that in mind.
Okay.
I appreciate that the defense didn't get notice of these exhibits until after I was in bed last night.
Sure.
Also, please bear in mind that the defense's moving papers are somewhat vague and uncertain. And rather than litigate their sufficiency under Rule 12, the state has decided, perhaps at some risk, but the state has decided to just roll with this. And in doing that, it is unclear precisely what evidence we will need to respond to the defense's motions, because at this point, I don't think we're really on proper notice. So we have taken an expansive view with the hope that we have swept up all the evidence we may need. That, of course, will be ultimately determined once we receive more substantive papers from the defense.
We'll see where this goes. The defense certainly is reserving its objections based on or regarding the reliability of the state's evidence, and we'll see how it shakes out. Okay. With that, go ahead.
One more, Your Honor.
Yep.
Not only is there 1 through 149, as we have done in the litigation so far, there are certain documents on the court's docket that we will be referring to throughout today. For example, 214 is the walk the dog letter.
Understood.
And we will refer to in our opposition papers.
Okay. Understood.
Your Honor, subject to the off-the-record discussion this morning, the state calls Detective Eric Maynard.
Okay. I'm going to adjust that a little bit. On the record, but sealed discussion we had this morning. Sam, I need you to stop video recording for a moment. Thank you. There will still be an audio record of Detective Maynard's testimony. Ms. Nestor, you're looking at me. You ready to go? Okay. Let's call Detective Maynard. Zach, will you let Detective Maynard know we can have him in now? Thank you. It's okay. Mr. Bloodworth, are we ready to go?
Yes, Your Honor, we're ready to call Detective Woody.
Okay. Brittany, are we on the record? All right, let's call the state's next witness, please.
Your Honor, the state calls Detective Jamie Woody.
Detective, if you'd step in front of Brittany, we'll get you sworn in.
If you'll please raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Have a seat.
Good afternoon, Detective Woody.
Good afternoon.
Are you a K-9 patrol deputy with the Summit County Sheriff's Office?
I am.
Back on April the 13th, 2022, were you a detective with the Summit County Sheriff's Office?
I was.
And at that time, were you the lead detective investigating the death of Eric Richins?
Yes, sir.
And at about 10 o'clock on the morning of April the 13th, 2022, were you preparing to execute a search warrant on the Willow Court address where Ms. Richins then resided and on the defendant's person?
I was.
At about 10 a.m. that morning, where were you physically preparing to execute that warrant?
At the sheriff's office.
And were you planning how you were going to execute the warrant at that time?
We were.
Did there come a time right about 10 o'clock when you received word that Deputy Maynard had stopped the defendant a short distance from her home?
Yes.
What did you do upon receiving that word?
I proceeded over to that location.
To the location of the stop?
Correct.
Once you were at the location of the stop, what did you observe?
I observed Kouri in the vehicle, the detective's vehicle.
And was she in the front passenger seat?
I believe so, yes.
Did you record this interaction with the defendant at all?
I did an audio recording.
Have you recently reviewed that audio recording?
I have.
And is that audio recording a fair and accurate representation, meaning it's not been altered at all?
Correct.
Your Honor, that audio recording is found at Exhibit 5 in the state's binder. A transcript of that audio recording is found at Exhibit 6. At any time during this interaction with the defendant, did you observe her in handcuffs?
No,
Did you place her under arrest?
I did not.
Did you observe her crying? Did you observe any tears?
I did not observe any tears, but she sounded like she was crying.
But no tears.
No.
Do you recall a time when you asked the defendant if she wanted to come with you and grab her cell phone?
I do.
What happened then?
We walked over to her car, and I believe she reached in and grabbed the phone and handed it to me.
When she handed you the phone, or as she was handing you the phone, do you recall a discussion about the phone's case?
I do.
Can you turn, there's an exhibit binder in front of you. If you can turn, please, to tab 6 of that exhibit binder. Is that a transcript of the audio recording of your interaction at this time and date with the defendant?
Yes, sir.
Can you turn, please, to page 11, look at line 1, right at the very top, where you say, "Do you want to come with me and grab your phone real quick?"
Okay.
And is that the point where she exited Detective Maynard's truck and walked with you to her car
Correct.
and reached into her car and retrieved her telephone?
Yes, sir.
Do you see down at line 11 where you asked, "Do you want to take it out of the case or not?"
Yeah, I see that.
At the point you ask that, who is holding the phone?
Kouri is.
And Why did you ask her if she wanted to take the phone out of the case?
I usually ask that if there's something attached to it, cards, driver's license, something like that, that I don't want to take with me.
Ultimately, she did not remove the phone from the case?
Not that I recall.
And after you asked her, do you want to remove the phone from the case, that is when she handed you the phone?
Yes, sir.
Okay. Please turn the page to 12. I want to clarify one thing. On line 9, it talks about an unidentified male speaker. Is that male speaker Detective Maynard?
It is.
At line 10, you say, kind of in a conversation that's unclear, I'm looking to clarify it here. You say, give you that, and then I. Is the that in line 10 the cell phone?
Object deleting.
Overruled.
Correct.
If you could please read below to line 13. At this point in time, it appears you're speaking to the defendant. You say, then he'll follow you back and you can do that. Is the hill Detective Maynard in that sentence?
It is.
Is the that provide you with phone numbers out of your cell phone?
Correct.
After your audio recording, where do you go?
I go over to Becky's house.
And Becky was Becky an employee of Eric Richins' company that had some electronic devices that you were interested in recovering?
Yes, sir.
And is Becky's house right in front or right off the street where Detective Maynard stopped the defendant?
It was.
So you wanted to walk straight from the stop kind of to the closest house
Correct.
to retrieve some electronic gear?
Yes, sir.
Okay. When your audio recording stops, do you have any other interaction with the defendant at the location of Detective Maynard's stop?
Not that I recall.
Okay. When do you next have any interaction with the defendant?
At the home, at the Willow, I think it's Willow Court.
The Willow Court address. Okay. What interaction do you have with the defendant at the Willow Court address?
I believe we asked if she would either provide the safe code or open the safe up at the home.
And did she?
She did. She wanted to ask a few questions and ask about the warrant and what we found and stuff.
Okay, set the scene. What are you doing at the home?
I'm walking around trying to help serve the search warrant.
At this point in time, other than asking for a safe code, are you at all questioning the defendant?
No, sir.
You said she was asking you questions. What does this look like? What are you doing and how is she asking you questions?
We're just kind of walking back and forth to the safes, and she's kind of following behind me, asking different questions.
What types of questions?
Questions about the warrant, I think questions about what we were looking for, what we found, things like that.
At this point in time, what was your interest at the house?
Just to serve the warrant.
At this point in time, were you at all wanting to interact with the defendant?
No, sir.
What did you want to do?
I just wanted to serve the warrant and finish it.
No further questions, Your Honor.
Ms. Nestor.
Thank you, Your Honor. Good afternoon.
Good afternoon.
My name's Kathy Nestor. I'm one of the attorneys representing Ms. Richins. I do have some questions for you today.
Okay.
I want to talk about the search of the home. You were the person that went and asked the judge to issue a warrant, correct?
Correct.
And the way that process works is you fill out an affidavit of a sworn affidavit saying all the facts that you believe support a search of a home. Is that right?
Correct.
And you specifically tell the judge what it is you would like to search, correct?
Correct.
I'm sorry. And then you also tell the judge what you're looking for generally, right?
Correct.
To try to keep it narrow as you can, right?
Correct.
And in this case, before you all showed up at the house and executed these warrants, at that point you had gotten 2 warrants, is that right? Signed by judges.
I believe so.
Okay. The first warrant you got maybe 2 days before that authorized a search for fentanyl and any kind of mailing or tracking instruments that would indicate purchasing something, right?
I believe so.
And then the second warrant you got, and again before you executed, was asking to search the home and Ms. Richins' person for electronics such as phones, computers, things like that. Correct?
Yes, ma'am.
Okay. Neither of those warrants did you seek authority to search a vehicle. Is that right?
Not in those 2 that I remember.
Okay. As a matter of fact, you went back later while you were in the middle of your search and asked a judge to issue a third warrant authorizing you to search vehicles. Is that right?
That sounds correct.
And do you remember what time you did that?
I do not.
Okay. And was that warrant issued?
I believe so, yes.
Okay. And did you go ask for that to be issued after you got back to the house, after you had already talked to Kouri with with Detective Maynard?
Yes, it was after that we left the stop.
So at the time that you got the phone out of Kouri's vehicle, you did not have a warrant authorizing the search of any vehicle. Is that right?
I didn't get the phone out of the car.
Okay. We'll get to that in a minute.
Oh, okay.
When you were at the car with Kouri, you did not have a warrant authorizing you to search a vehicle, correct?
No, ma'am.
And in fact, you knew you needed another warrant because later that day you went back and got another one, right? That authorized vehicles.
Objection, Your Honor. That needed another warrant is unclear as to why she needed another warrant. Indication that she needed another warrant to search the car is unfounded.
I'm going to allow you to answer the question. I can weigh the testimony as needed. Do you need it or repeat it?
I do.
Okay, so you knew you needed a third warrant to be able to search vehicles and actually went back and got a third warrant, correct?
For the vehicles at the house, yes.
Correct. Okay. All right, I want to talk about when you first arrived, where Ms. Richins was seated in the vehicle. You had an audio recorder on,
Yes, ma'am.
but not video?
I did not.
Okay. And the transcript the government has referred to, the state, I'm so sorry, that the state has referred to, is it in front of you? Yes?
It is, yes.
Okay, great. All right, so can we turn to page, let's see here. All right, can we turn to page 7? Oh, wait a minute, I'm sorry.
Are you looking at exhibit? Is this exhibit 1?
6, Your Honor.
6, yes, 6. Sorry, I should have said that. Thank you, Your Honor. Let me back up even further than that, just a minute. Okay, so let's go to page 3, where Kouri's asking you what's going on. And starting at line 7, what do you tell her the purpose of your search is?
It's to make sure that there's nothing there, there's nothing dangerous, and there's nothing dangerous for her and the kids.
And when you say nothing dangerous, you were talking about what?
Drugs.
Specifically, what kind of drugs?
I don't know if it says in the warrant or not, but in this instance, I was talking about fentanyl.
Fentanyl. So you're telling her that you're checking to make sure there's no dangerous fentanyl in her house that could harm her or her children. Is that right?
Correct.
And in fact, you guys kind of had a conversation about how if there's just any little bit of fentanyl, it can be super dangerous, right?
Yes, ma'am.
Okay. And then if you could go to page 5. No, I'm sorry, not page 5. I think it's page 7. Sorry, page 7. Line 16. And you ask her, do you have a phone with you? Is that right?
Correct.
And this is when she's still sitting in the car being
Correct.
detained, right? And then she answers, I have my phone, yeah. And what do you ask her?
I ask her, is it in your pocket?
And what does she say?
She says, we have phones. We have no, it's in my car.
It's in my car. Okay? So there's really no dispute that at the point she's sitting in that car, it was not on her person, correct?
Correct.
Okay. Then, if you go forward to page 11 at the very top, you say to her, do you want to come with me and grab your phone real quick? Is that right?
Correct.
All right. Prior to that, did you ever give her Miranda rights?
I did not.
Did you ever tell her that she had an option whether she cooperated with you or not?
I don't believe I did say anything like that.
What were you wearing that day?
I was wearing a blue shirt, like a polo, and a black jacket, and I usually had either gray or khaki pants.
Right. And on that blue shirt, there's an insignia for the Summit County Sheriff's Department. Is that right?
Correct, but it's covered by the jacket.
And the jacket identifies you as law enforcement?
It does not.
Does not. Did you tell her? She knows you're law enforcement, right?
She should, yes.
Because you guys had talked before.
We have, yes.
You had asked her to be interviewed, right?
Yes, ma'am.
And then you knew she had a lawyer.
Correct.
Because you had talked to her lawyer about arranging an interview with her.
Correct.
And you knew she had a lawyer at the time you were talking to her that day out on the street, right?
Correct.
And did you advise her she had a right to call that lawyer and get advice?
I did not.
All right. And then on the last page, page 12, I'm sorry, you guys walked to the car, is that right, together?
Correct.
Where were you standing when you guys walked to the car?
I don't remember.
Right. And when you got to the car, where was the phone?
I don't remember.
It wasn't on her. It was in the car.
Correct.
And you asked her to hand you the phone. Is that right?
Your Honor, again, this is recorded, or I guess it depends where.
The transcript says what it says. What's your question, Ms. Nestor?
You asked her to hand you the phone.
I would have to look. I can't remember
Okay.
exactly what I said.
Let's look at page 11. Where you say, do you want to take it out of the case or not, right?
Correct?
And then you take the phone from her. So you didn't even ask her, you just took it. Because it looks like you're not asking her, you just take it from her.
No, I asked if she wanted the case, and then she handed it towards me.
Okay. And did you tell her before that she didn't have to?
I did not.
And when she handed you her phone, you then told her that Detective Maynard would follow her back to the house. Is that right?
I'd have to look. I may have.
Look at the last page, page 12.
Correct. I did say he would follow you back.
Right. And he did follow her back, did he not?
I assume so. I wasn't I wasn't there at that point, I don't think.
Oh, because you'd gone to Becky's house?
Yes, ma'am.
How did you arrive? Were you in a police car when you got there, or a sheriff's car?
I assume I was in my unmarked vehicle.
So, at what point did you give the phone back to Detective Maynard?
Would have been probably when we walked back towards his car, towards where he was standing.
You say probably. Do you remember?
I'd have to look at this to remember exactly when and what I said.
So, if it doesn't say here, you don't remember?
Some things I do, yes.
Do you remember when you handed him the phone?
When I walked back to the car.
Okay. How long did it take for you to get back to the house?
I am not sure.
When you got back to the house, did you ever take the phone back from Detective Maynard?
At some point, I did.
Did he advise you that he had obtained the passcode from Ms. Richins?
I don't recall.
Do you know what you did with the phone when you got it back?
At some point, I would have taken it back and put it into evidence.
Okay, but you don't remember.
No, ma'am.
Okay, that's fair. I know it was a while ago. Just trying to get the difference between what you remember and what you don't, okay? So at some point you said you had another conversation with Kouri where she helped you go to the safes in the house, is that right?
Correct.
In fact, did you go out and ask her to come in and open the safes?
I believe I asked if she would provide either the code or open the safe so that we didn't have to damage them.
And when you did that, did you advise her she had a right to refuse?
I did not.
Had she been Mirandized to that point?
She had not.
How many
that I know of.
How many police officers were on the scene, or sheriffs were on the scene while you guys were doing that search?
I'm not sure.
Help you with that. Sorry, just 1 minute, Your Honor. Were there more than 10?
I'm not sure.
Were there more than 5?
More than likely.
Okay. All right, so you asked her to open up the safes. You mentioned that while you were going from place to place in the house, before you went in the house, where was she when you asked her to open up the safes?
I believe she was in her car, or a car.
Right. And when you asked her to open up the safes, you guys went inside the house and you also went into the garage and the removed garage. There's kind of 2 garages, right?
Yes, ma'am.
Okay. You mentioned when Mr. Bloodworth was talking to you that she was asking you questions about what you had found. Is that right?
Correct.
Was she asking you if you had found any dangerous fentanyl that was a danger to her or her sons?
I believe she was asking that, yeah.
Okay. All right. Okay. At what point were you removed from this case?
I left a little while after I got the dog, so I'm not sure what date or anything that would be.
When you first got this case, you're from a small town, is that right?
Correct.
And I'm not going to say it, but you knew the Richins family before all this happened, right?
1 second.
Objection, Your Honor. This is far afield of the scope of the pending motion.
Goes to credit.
A little confused where we're going.
Give me just a little bit of leeway, and I think I'll show you. Just give me a couple more questions.
You got to give it a name, though. Is this a...
It's credibility.
All right. I'll give you a limited leeway here.
So you knew the Richins family before you were investigating this case, is that right?
No, I don't think I knew any of these guys. There's a lot of Richins that live there, but I don't think these guys specifically.
You did not?
Not that I recall dealing with them.
Okay, thanks. That's all I have on that, Your Honor. See, just a moment. I think I'm almost finished. Oh, after you guys did the search on the house, you heard from the defendant's lawyer, did you not?
I don't recall.
May I approach,
Objection,
Your Honor?
Again, anything that happened post-search is irrelevant to the pending motion.
Your Honor, this is because we're going to have a little bit later today a challenge to Detective O'Driscoll's interview of Ms. Richins when she was uncounseled. And this is the individual that got the assertion from the lawyer. And so I'm just laying a foundation for when I do O'Driscoll later.
Proffer the assertion.
I do. I have it.
What is it, though? Help me understand.
Oh, that her lawyer asserted Sixth Amendment rights and told them not to speak to her client again.
Will allow them to lay this foundation.
Your Honor, we're going to have to put a lot of objections onto the record here.
I'm a little bit blind here, so if you
Sure.
can just provide a little context.
So, as Ms. Nestor just said, she's making a Sixth Amendment challenge to a later interview. That later interview was conducted on April the 14th, 2022. By April the 14th, 2022, or on April the 14th, 2022, judicial proceedings had not begun. Thus, the Sixth Amendment had not attached. Therefore, any discussion about a Sixth Amendment violation is irrelevant. The Sixth Amendment right to counsel had not yet attached.
Okay. We still have, well, I don't know what Detective O'Driscoll is going to say. This sounds like 2 or 3 questions, am I right?
Uh-huh.
I'm going to allow some limited latitude here. We'll see if it matters or not later.
Okay, Your Honor.
What I understand Ms. Nestor is going to ask about is a communication or 2 sent to her by Ms. Richins' prior counsel. Correct, Ms. Nestor?
Yes, sir.
And after that, are we done?
Yes.
This seems reasonable, even if ultimately irrelevant.
I am trying to comply with your request that we lay foundations through the appropriate witnesses.
Sure.
So this would have been part of the case file at the time she left and O'Driscoll took over.
I guess what I'm saying is, why don't we just let these 2 questions come in, and then we'll see if we need to ever address this again.
Fair, Your Honor. The state would not object to the admission of these emails. The only thing the state would say is there is also metadata that attaches to the emails that, to the extent the metadata becomes relevant, it's in discovery, of course. That
And if we need to get into that, we
consider
can.
that
Is
in
there any
addition.
reason to suspect that the header of the email regarding to, from, and time and date is incorrect?
No, Your Honor,
Okay.
that's not.
All right. Can I just see him, Ms. Nestor?
Your Honor, this is going to be 152.
Thank you. Ooh, my.
Thank you.
It's very small type.
Take just a minute. Detective Woody, Deputy Woody, are you still detective? I want to call you the right title.
Just deputy.
Deputy. Will you take a minute to review that and see if those look familiar to you? And I'll give you just a minute and then I'll ask you about them.
Okay.
Your Honor, can Mr. Bloodworth borrow that copy for 1 second?
In just a moment. My apologies.
Well, yeah, gotcha.
Just let me know when you're ready. I don't want to rush you.
Okay.
Oh, I was talking to her. Sorry, not
No,
you.
that's okay. If you would hand this to Mr. Bloodworth for me, that's fine.
I've scanned through it.
Okay.
So I can.
Does it ring a bell? Do you vaguely remember it?
Yeah.
Okay. And as I understand it, that is an email and letters that were forwarded to you as the case investigator informing you that the lawyer did not want Ms. Richins spoken to again outside the presence of counsel. Is that right?
That's what it
Your
looks
Honor,
like.
objection, that mischaracterizes the emails.
The
and
email
letters.
says what it says. Can we just have some foundation as to whether or not that email ever made its way through this witness to Detective O'Driscoll?
My next question.
Okay, let's just get that out and then we can
Okay.
move on.
When you got this email and these letters, what did you do with them?
A while ago, I don't remember. I probably showed my boss, or I would assume.
Who was your boss?
Back then, it would have been probably Detective Davis, maybe?
Davis? And is it your practice that when you get documents that are related to a case that you take them home or throw them away? What do you do with them?
Generally, they go into a case file.
And did you have a case file on Ms. Richins?
There was a case file, yes.
Physical file
Yes.
that was yours as the chief investigator?
Yes, ma'am.
And did you put those documents in there?
I believe I did, but I can't answer for sure.
And when you left the case, did you provide all of your materials to Detective O'Driscoll?
I did.
Okay. Really quickly to go, that's all I have on that, Your Honor. And we do offer 152.
152 has been offered.
To go back to the warrant, when you came up on Kouri, when she was in Detective Maynard's car, did you ever serve a copy of the warrant on her so she could see that you had a search warrant?
Not at the car, no.
Did you ever give her a copy of the warrant?
We did, yes.
When?
I'm not sure. I know she had a copy at the house, but I don't know when.
Okay. And is there some reason that you quit working on this case other than you're wanting to go train your dog?
No, I didn't have enough time for the dog, pretty much.
I respect that. I think that's all I have, Your Honor. Just a moment.
I just need to get that back from you when you're done, Mr. Bloodworth, to add it to the exhibits. Thank you. Let Ms. Nestor check with co-counsel and then we'll.
Yeah.
Your Honor, we tender the witness. Thank you.
Mr. Bloodworth, anything further?
No, Your Honor, thank you.
Okay. May we release this witness, counsel?
Yes, sir.
Okay. You're free to go. Thank you.
sir.
Mr. Bloodworth, does this conclude the state's initial case, or do you have more witnesses?
No, Your Honor, the state has two more witnesses.
Rough estimate of how much time you have with the first of those people?
15 minutes.
Why don't we call that person?
Okay.
Yeah.
Your Honor, the state calls lead crime scene investigator Chelsea Gibson.
Okay. You may be calling somebody else next, or we may be taking a lunch break. Zag, is Chelsea in the lobby?
No, there's a miscommunication. She's kind of.
That's okay.
Yeah, Your Honor,
That's fine.
when we thought we were
Yep.
going to break for lunch, we sent her back to her office.
Would you like to take a break now? Would that be better for everybody? We got to take one eventually.
Your Honor, I think we do it. I should be here in a minute.
Okay, sounds good. Ms. Nestor, Ms. Lewis, you okay with that?
Yes, sir.
Okay.
I don't know about him.
He doesn't eat.
He didn't eat, yeah. We don't feed him.
I'm just convinced that you're running the show. Ms. Gibson, if you'll step in front of Brittany, we'll get you sworn in. Thank you.
You'll raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Please have a seat.
Mr. Bloodworth, please proceed.
Thank you, Your Honor. Ms. Gibson, are you the lead crime scene investigator for Summit County Sheriff's Office?
Yes,
And have you been a crime scene investigator with the office since, at minimum, April the 13th, 2022? As a crime scene investigator for the Sheriff's Office, your duties include phone extractions.
yes, they do.
What computer forensic tool does the Sheriff's Office use for phone?
Celebrate.
What training and experience do you have in using Celebrite?
I'm certified in downloading and analyzing the phones.
And approximately how many phones have you downloaded?
50.
Are you familiar with the defendant's phone taken into evidence on April the 13th, 2022?
Yes,
How are you familiar with that phone?
it was booked into evidence.
And were you the crime scene investigator that took it into evidence or runs that evidence room or whatever?
Correct.
Was that phone an white iPhone Model 12 with an IMEI number ending in 2558?
Yes, it was.
Did there come a time when the Celebrate forensic tool that the sheriff's office used had the capability to extract data from an iPhone Model 12 without using a password?
Yes.
At what point in time did the sheriff's office have that ability?
December of 22.
Did there come a time when the sheriff's office or a partner law enforcement agency extracted the data from that iPhone Model 12 IMEI 2558 without using a passcode? When did that occur?
September of 24.
And did that extraction occur pursuant to a warrant issued on September the 27th, 2024?
Yes.
Thank you. No further questions.
Ms. Nestor?
Thank you, Your Honor. Good afternoon.
Good afternoon.
My name's Kathy Nestor. I'm one of the attorneys representing Ms. Richins. I do have a couple of questions for you. So do you work in the Regional Computer Forensics Lab?
No.
So you actually work for Summit County Sheriff.
Correct.
And I heard Mr. Bloodworth ask you, are you the one who took this phone into evidence? Can you expound on that for me? What was your connection? What did you do with this phone?
So when phones are brought to the sheriff's office, I manage the evidence room.
Keep going. I'm sorry. I just need to grab a document.
You're good.
Keep going.
From what I recall, Detective Woody at the time booked it into evidence, placed it into a locker, and then once it's in the locker, then I take custody of it and put it into evidence storage.
And every time you touch a piece of evidence, you guys keep a log. It's called a chain of custody form. Is that right?
Correct.
Your Honor, may I approach?
Yes.
Your Honor, we would mark this number 150.
All right. What is it?
It's a chain of custody form, Your Honor.
Okay, give us one moment.
Deputy Gibson, I'm handing you a document that's marked as a chain of custody form, I guess.
Yes.
Can you look at that and tell me if it looks familiar to you?
Yes, it does.
Is that your handwriting on it?
Yes, it is.
And can you explain what this document is?
It is releasing the phone from me to Detective Crowley to RCFL, back and forth all the way to the RCFL to get the download from the phone, and then chain of custody of that phone coming back to the evidence room.
Let's look at the dates on this. I think you testified earlier that the soonest you were able to download off of phones, the soonest the sheriffs had the software capability to basically crack a phone and download it without a passcode was December of 2022. Is that what you testified?
Correct.
Okay. And the document that you have in front of you, what is the date that you turned over the phone to the RCFL?
5/4 of 22.
May of 22.
Correct.
All right. And at the bottom, there's a comment. What did you write on the comment?
RCFL for phone dumps.
So tell me what that means.
It means it was released to RCFL to obtain a phone download.
And RCFL, just to clarify for the record, it's the Regional Computer Forensics Laboratory that often does do phone dumps, right?
Correct.
Okay. So you gave it to them in May of 22. When did they return it to you? Or when did it get returned, I guess? Who's Crowley? Do you know who Crowley is?
Detective Crowley. He was a detective for Summit County Sheriff's Office at the time.
Okay, so when did the RCFL send the phone back? In other words, we're done with it. Here it is. It's back to you.
July of 22.
Again, before you had the capability to crack it without a passcode, right?
Yes.
And when you got the passcode, were you advised, when you got the phone, sorry, when you got the phone, were you advised they had a passcode for it?
When I received the phone, I believe there was a passcode on the property tag of the device.
Right. So you already, and you provided that to RCFL, right?
It was provided, yes.
Okay. Okay. Were you on the scene of the search of this home on April the 12th, the 13th of 2022?
Yes, I was.
Did you ever have the phone in your hands that day?
No, I do not believe so.
Were you aware of anyone looking in the phone that day when you all were at the house, at the Richins home?
Not that I'm aware of.
Did you prepare the what's it called? The property seizure form from the search that day, or was that not your job?
I'd have to look at the handwriting to verify if it was me or my coworker at the time.
Okay. May I approach, Your Honor?
Yep.
Your Honor, this will be Exhibit 154.
Thank you.
It doesn't look like that's your handwriting
No.
from what I just looked at. Did you prepare that form?
I did not.
Okay. Did you ever see it that day?
Yes.
All right, can you look through that form? As part of your duties on the scene that day was to kind of make sure that all the evidence that was being gathered was properly accounted for?
Yes.
That was part of your responsibility?
Correct.
Can you look on that form and tell me if you see anywhere that a phone was seized from the home?
There's not on this one.
That's. Let me hand you another document. May I approach, Your Honor?
Of course.
This is number 155.
Thank you.
I'm going to hand you another form that is titled Evidence from Search. See the form that says Evidence from Search?
Yes.
It looks like an Excel spreadsheet, something like an Excel.
Yes.
Did you prepare that?
I did.
You did?
I did.
Okay. On that document, the very last entry refers to an iPhone.
Yes.
All the other documents, or most of them, not documents, things that were seized, appear to be linked on your spreadsheet to where they were found. Is that right?
Correct.
Where does it indicate the phone was found?
I did not have a location of the phone on this document.
So is there any other thing on that document that you don't know where it was found other than the phone? Or is that the only item?
It looks like there's an item that's titled pills and one titled scene photos.
Okay. The pills one, does it say how many pills were seized?
Not on this spreadsheet, no.
Okay. All right. I think that's all I have, Your Honor.
Mr. Bloodworth.
Can we,
Yeah.
can the witness keep that? I'm going to start.
Yeah, I just want to show this to Alex for 1 second, make
Sure.
sure there's not no more questions. Your Honor, we tender the witness. Thank you, ma'am. Thank you. Yeah. Let's take this one. And this one.
Let's please pick up where the defense counsel left off. 155, I think it's on there. That's the spreadsheet that you said you prepared. Why did you prepare that spreadsheet?
There's a lot of items regarding this case, and there's also several different case numbers regarding the sheet, so it made it a little bit simpler to combine the several cases onto a spreadsheet at that time.
Was it simply a tool for you to use?
Correct.
Please return to Exhibit 154, the property seizure form. You testified that there is no cell phone identified on that property seizure form. Why is that?
And sorry, there is one on here.
There is one on there.
Yes.
But is this the property seizure form for the Willow Court address, right?
Yes.
And it's not the property seizure form for any property that was seized off of the Willow Court address, is that right?
Sorry, repeat the question.
It's not a form that documents property that was seized off of the Willow Court address, is that correct?
Correct.
So if a phone was seized off of the Willow Court address, you would not expect to see it on that property sheet?
Correct.
Let's return, please, to the discussion regarding the RCFL. You recall looking at the chain of custody form, which transferred custody of the phone from the sheriff's office to the RCFL and back to the sheriff's office, right?
Yes.
Do you know whether or not the RCFL extracted that phone?
Yes, they did.
Did there come a time when the RCFL transferred, I don't know, tell me if it's on a hard drive or however, they transfer extractions back to you, the Summit County Sheriff's Office?
Yes. On a hard drive.
Okay, so there came a time when the RCFL transferred the extraction to the Summit County Sheriff's Office, and the Summit County Sheriff's Office has a copy on a hard drive of that extraction.
Correct.
Were you able to access, was the Summit County Sheriff's Office, as far as you know, able to access that extraction?
Not for a while.
Okay. And why not for a while?
We did not have the capabilities at the time to look at the download.
Okay. Do you know if the Summit County Sheriff's Office ever reviewed that extraction?
Sometime after December of 22,
Okay. If at all?
if at all.
Okay. Thank you.
Your Honor, can I follow up on that was just newly brought in, just very briefly, about the extraction?
Yes.
So I want to make sure I understand. So we looked at the fact that you sent the phone to the RCFL in May of 22, right?
Correct.
And they sent it back to y'all saying we're done with it in July of 2022.
Yes.
And then they sent you what they got off of it on a hard drive.
Yes.
And it just took you a while at the sheriff's department to have the software to open their hard drive, right?
Yes.
And have you ever seen, let me back that up. You never went back and got a second hard drive from the RCFL. You just ultimately were able to open the one that they gave you back in July of 22.
Correct.
That's all I have. Thank you.
Okay. May we release this witness?
Yes, Your Honor.
Yes, sir.
You're free to go. Thank you. Yeah,
Let me get that back.
thank you.
Oh,
Do you want those copies
There.
back, Ms. Nestor?
Here's the one that's marked, Your Honor. I might